Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Global Law and Business. It's called International Arbitration, A Practical Guide, and it's been written by three people: Stuart Dutson, Moody and Neil Ewing. Elizabeth and I talked about this book because arbitration is an important area of dispute resolution, and we've given it a title from a practitioner perspective: International Arbitration Clearly Explained. This book is not brand new, it's been around for a little while, but we thought it would be of interest to review it now because of the way things are going with the basic concepts of arbitration. Let's look at the book first of all. It's a hardback. There it is. See the front? Just turn it over so you can see that. The spine. And then on the back, you probably can't read anything that's actually on there because it's it's a little difficult to read. On the back of the book, we've got the actual index. Now, the index is by page numbering. You should be able to find things quite easily. The book runs to about 300 pages, and it's very much in the house style of Globe Law and Business. That's the beginning of the index. All references are to page numbers. Then at the back of the book, you have, as is the style for Globe, you have the detail about the authors at the back. And then you've also got there some useful schedules right at the back. Now at the front of the book, again, it's the house style, again, it's the structure there like that. Then you've got the blurb about the book, and then you've got the actual table of contents. A preface at the beginning, it's always worth reading, and then we've got a range of contents, a total of 15 actual chapters, then details about the author and the index. Then you go into the preface straight away. It says, for instance, a very important point: ultimately, international arbitration is merely a form of dispute resolution, and that's exactly what it is. Then we get the question: what is international arbitration? And it expands on that point. It runs all the way through. You can see that there are some blocked out bits there with tips about what to do. I think it's quite useful for anybody who's involved in arbitration from the more detailed aspects of arbitration, because today international arbitration is an important area. You can see the middle of the book there. This international arbitration, London of course is a big centre for it, and of course it's something that I think will be with us for a very long time, because it is one way of resolving disputes. Obviously the final dispute resolution is the court itself, but this is one way to get away from the very strict and very actually unnecessary complicated stuff and things like the White Book, which really does make things much more complicated. I don't think it was designed that way originally, but I'm afraid it is. There we go. Now, about arbitration. As business grows ever more multinational, so the need for international arbitration becomes increasingly urgent. For practitioners keen to enhance their understanding of this fast developing area of law, this text from the aptly named Globe Law and Business is ideal, we think. But is international arbitration, strictly speaking, an area of law? Now, the co-authors, Stuart Dutson, Moody and Neil Ewing, are all from Eversheds Arbitration Group in London, and they are content that it is. They refer to it specifically as a separate discipline within the law, as evidenced by the procedures and practices applied within it. And I think that's right, bearing in mind where we are at the moment, with, I think, very substantial overhauls of the legal systems, with obviously information technology, computers, online courts, all the other things that are happening with the new devices that we have today. We still get down at the end to people in a room, putting it in its crudest form, but at the moment we are looking at a whole range of different ways when there are disputes to try and settle them. Said practices and procedures, the authors go on to say, are not presented in the way that court rules are delineated, pointing out that the court rules of the High Court of England and Wales, contained in the White Book there, comprise 2 volumes, at least 4,000 pages at the last count, probably more, with the new edition coming out in March 2019. So be prepared to be amazed then, by the revelation that the arbitral rules of most leading institutions can be contained in only a few pages. And as I say, simplicity could well be the key in the future. Who knows? International arbitration, the authors remind us, is merely a form of dispute resolution, yet obviously as thornily complex as the dispute itself. Parties who select this method of resolving disputes have therefore chosen it as an alternative to the courts. Nonetheless, the underlying law and rules of international arbitration need to be examined and explained in a clear, straightforward manner, which is what this book very skillfully does, as we are reassured at the outset that the final decision of an arbitrator or arbitral tribunal is an award that is final and binding on the parties. And this, of course, has been the problem in the past. Written with the practitioner in mind, then, the book is logically organised with a detailed table of contents and index, plus the time-saving feature of useful tips galore, highlighted in boxed shaded sections throughout. And another useful feature which makes the book well nigh indispensable for arbitrators is the 64-page appendix containing a lengthy table of comparison rules, which, to cite only one example, compares Swiss rules with UN CITRAL rules and many more. Now, the case for choosing international arbitration is stated in a succinct and convincing manner, and the arbitration process from pre-commencement of proceedings to the hearing itself and beyond are carefully explained, including the legal framework and such matters as pleadings, witness evidence and more besides. Equally important are the final chapters on costs and the enforcement of the award, or for that matter challenging it. So here then, just to conclude, is a practical guide to the international arbitration process, which I think is developing at quite a quick pace since this book first appeared a few years ago. So international lawyers, or indeed anybody interested in this fast developing area of practice, would do well to acquire it in our view. And I'd like to thank everybody concerned for the production of the book, including, of course, Sian O'Neill, who has been excellent as the managing director of the of Globe. Let's just look finally at the book again. There it is, International Arbitration. There's the back of the book. You can't really see much, as I say, and then there's the section, the spine. Let me just open it. This is developing a case. This is an interesting, halfway through the book, requesting documents. Now, again, very simple sort of request, you would have thought. No, it's much more difficult than that. So there are tips to give you an idea of how you go about doing things and what to look forward to. You've got, of course, the issue of privilege and confidentiality to look at. And again, there's cross-referencing, again, in the boxed areas, which I think helps. And then you've got an appendices, again, which follows that. You can probably see the form that's set out there. That just gives you a flavour for the book. And I'm very grateful, as I say, to everybody concerned. It's a practical guide and extremely useful. So a big thank you to everybody concerned for its production. Bye-bye.